It was further assailed that the prosecution case by contention that, of course, as per the report of the Forensic Science Laboratory, the blood-stained earth as well as the bedsheet recovered from the scene of crime were found stained with human blood, but it is absolutely silent about the blood group, and that being so, it ought to be excluded from the consideration. This argument has no legs to stand upon. If there had been recovery of weapon of offence and oblique or of the blood-stained clothes of the accused only, then this argument could have been raised. It has been observed that the two decisions referring to Supreme Court cases turned on the peculiar facts of each case, and they do not lay down a general proposition that in the absence of determination of blood group, presence of human blood on the weapon or garment of the accused is of no consequence. In view of these observations, this contention holds no water. The next argument having been raised by the learned counsel is that the prosecution case rests upon the solitary statement of PW8, who has stated that the appellant had already run away before they reached the place. This evidence leaves no scope for doubt that the occurrence was not witnessed by him, and thus the entire prosecution case is demolished. A careful reading of the examination in chief of this witness would reveal that he has given a graphic description of the occurrence, and on evaluating the same, it stands abundantly established that the occurrence was witnessed by him. More so, his presence is probabilized by the fact that he, along with others, was watering his paddy crop fields in the close proximity of the place of occurrence. He, along with witness, was attracted to the spot on hearing the shrieks of the deceased. It is an accredited rule of evidence that while on appreciating the statement of a witness, it is to be taken into consideration in its entirety and not by picking up a few sentences from here and there. It has been observed that the doctrine of false in one thing, false in everything is a dangerous one, especially in India, for if a whole body of the testimony was to be rejected because a witness was evidently speaking an untruth in some aspect, it is to be feared that administration of criminal justice would come to a dead stop. An attempt has to be made to separate the grain from the chaff, truth from falsehood. It is in the examination that Chief of PW1 that injured told him that the appellant wanted a big dera from him, and on his refusal to allot him a bigger dera, he has injured him. Obviously, the deceased narrated the occurrence, including the motive. Assuming that the occurrence was not witnessed by him, nevertheless, the deceased had disclosed the name of the accused to him, and further, this witness had seen the accused from back while fleeing from the spot. Ostensibly, the rule of res gestae has been applied in a similar situation, so even in the light of this rule, the deposition of PW becomes admissible. The conviction can be based on testimony of the sole witness without corroboration. There is no proposition of law to the effect that on the basis of solitary witness evidence, conviction cannot be recorded, and also that relatives evidence needs corroboration.